might end up at the Court of Common Pleas will save the taxpayers money. As an arbitrator and mediator, I was very successful in resolving high-end, high-value cases. And I think that if we try and bring more into the magistrate's level, at the district judge level, I think that we can save the taxpayers lots and lots of money by avoiding the use of the Court of Common Pleas.
So I run a law practice. I founded a law practice. People who know me know I am fiscally conservative. I have a very modest law practice. I often tell people it's not how fancy your office looks or what type of implements you have there. It's the quality of your practice. I believe in it personally and professionally. I work with it every day, and I certainly would continue to bring that to the Office of District Magistrate, especially because I would be doing it in the public trust.
We will now begin rebuttals of 30 seconds. Please, Mr. Rao.
Regarding the issue of settlement or arbitration, the rules don't allow for arbitration at the magistrate level, so that's that. Mediation may be possible with certain civil cases, certain landlord-tenant matters. Actually, I see Susan Jordan standing in the back there, the director of our local mediation center. Her and I will be meeting tomorrow to discuss that. So that's certainly a possibility. As far as being directly involved in settlement negotiations, though, you have to be really, really careful as a judge. Frankly, it's borderline unethical, and it's probably not something I would inject myself into.
Being on the Lewisburg Area School Board for so long, my experience with the public taxation and financial aspects is broad. I recognize that every penny we spend, we all pay for. And I think that if we can think outside of the box and approach things in a different fashion, I really think we can save some money. I have settled hundreds of cases, and they've involved the judges, and I'd be surprised if anyone thought that was unethical.
So again, being elected to the Office of District Magistrate in Lewisburg and following Judge Armbruster, big shoes to fill. I think the fact that he served for 39 years shows that he has had the public trust. I certainly would take a look at what is going on, the structure and the costs in the administration of that office, and try to implement a plan if it was needed, but if not, continue the way things are going, again, in the public trust.
Okay, question 5. And this will be the final question prior to the closing statement. Mr. Zitch, you will begin this, to answer this. Excuse me. I'm not doing a good job here of sorting these, so just bear with me for a minute. Yes. Question 5. Do you believe that plea bargaining at the magistrate level is appropriate? And if so, what would you do to encourage that?
I think that if the district attorney's representative and the defense attorney or the person who has been arrested in waiving the right to counsel come to an agreement as to how that can be resolved, that's certainly to the benefit of all concerned, assuming that the district attorney folks are satisfied with the result. So again, if we're looking at the fiscal responsibility associated with the office, I think that we need to take into consideration that a plea bargain, if appropriate for all concerned, would certainly be of benefit to the community.
So as a magisterial district judge, it's not appropriate for a judge to engage in plea bargains, but I will say as an attorney, it's a necessary evil, so to speak. For judicial efficiency, it's not unusual for the chief law enforcement officer, the district attorney of the county, to engage in good faith plea negotiations. It helps move cases along very quickly. There are many offenders that come to preliminary hearings that want to take responsibility for the offense that they've been charged with, and it's a very quick way for the matter to be disposed of. But I don't believe that it's appropriate for a judge to engage in plea bargains in any way.
When we're talking about plea bargains at the magistrate's level, we're talking about really two things. There's plea negotiations that take place on cases that are graded as misdemeanor 2s and higher, which the magistrate really can't have any say on whether the plea agreement is acceptable or not. They have to go to the Court of Common Pleas by law. So really what we're talking about is accepting plea bargains on third-degree misdemeanors, summary offenses, and non-traffic citations. Under Pennsylvania law, the judge has the ability to reject a plea agreement if he thinks it's inappropriate. And that's something that has to be made on a case-by-case basis. I know that's not the definitive answer that voters like to hear. That's the lawyerly answer, but every case is different. Every defendant's circumstances are different. Every victim's circumstances are different. Every arresting officer or citing officer has different opinions on the case. So you really do have to take it on a case-by-case basis.
We will now begin rebuttals of 30 seconds each. Mr. Zitch.
I really don't. I think that the issue's been explored. I by no means meant that the judge should engage in plea bargaining. I think that's up to the district attorney's folks and the defense attorney, and or if waiver of counsel has been obtained, the defendant himself or herself. But I agree. I think that as a matter of judicial efficiency, these things should be considered.
Again, I'll just reiterate, the judge should never engage in plea negotiations between law enforcement and a defense counsel. However, it is necessary for efficient judicial disposition of criminal cases or civil matters. So I think it is important for that function at a prelim. It does move cases along very quickly, but the judge needs to stay out of it and be fair and balanced.
The only thing I'll add, because waiver of counsel was mentioned a few times, I think it's important at every stage of the process to make sure it is a knowing, intelligent, and voluntary waiver. I mention that because a lot of times, especially with low-level criminal incidents, you will see folks who have some mental health issues coming into the courtroom. It's important that the magistrate be able to recognize those to make sure that the person is knowingly, intelligently, and voluntarily giving up their rights before accepting any disposition, even if it's just a waiver.